With the consent of the House, the rules be suspended, and substitute Senate Bill 6055 will be returned to second reading for the purpose of amendment.
A judge, unlike a legislator, does not create law and must abide by the statutes enacted by the legislature and rulings of earlier courts.
As a member of the judiciary, you don't get to do what I did in the legislature. You don't reach out and fix problems. You respond to the case that's in front of you. You're basically trying to make sure that the lower court followed the law. You're trying to make sure there's sufficient evidence to support the facts. You're trying to make sure they got it right. The Court of Appeals is a safety net, and that's a role very unlike the legislature, where you get to make policy and create the structure for government.
Mr. President. Conversations about race and racial disparities are really hard to have.
The mindset of a legislator certainly is different from that of a judge, because in the legislature you're representing people. You're trying to achieve what your constituents would want you to do. You're trying to see that their interests are taken into consideration. As a judge, that you're not representing anybody. You're trying to be a fair decision maker regardless of the issue that comes up. And so you may, in a case, have to rule against someone who's presenting the same issue, where if it had been in the legislature, you would have voted for it.
The Court of Appeals is bound to follow state Supreme Court decisions on state law and United States Supreme Court decisions on federal law.
I think every judge comes to a case with a sense of justice and fairness, but what does that mean in each individual sense? And that's where you have to be careful that you're not just deciding a case based on your own particular morals, although that's very important. We have to decide the cases based on the law and the facts before us, taking into consideration all of the circumstances. But we don't just decide the case on a gut feeling.
A Court of Appeals decision can affirm the outcome in the Superior Court, reverse and remand the case for a new trial, or reverse and grant judgment to the losing party at the Superior Court level. Even if the Court of Appeals finds an error in the trial court proceeding, the Court of Appeals may affirm the trial court decision if it determines the error to be harmless. If there is a reversal, the case is usually remanded for a new trial.
The definition of justice may be something a little different for every judge. My definition of justice is the parties have come before court knowing what the rules are, knowing what the law is, with a full expectation that they're going to be heard and that their case is going to be decided according to those rules. That's my idea of justice, and I think that happens here every time. We try to give people a fair hearing. We try to decide their case based on precedent and based on the law. And that way people can depend on us to do the right thing in the case and not worry about their case being decided on a particular judge's personality.
I think of the law, as a fortress. It stays very firm. It's reliable. Sometimes mistakes are made and they kind of fall away as time goes on, but on the whole, we're following the law and some really bedrock principles. We follow the bedrock principles that everyone in court is entitled to: a fair hearing, an impartial decision maker. They don't see it as they go about their daily lives, but the fact that you can take your money and put it in the bank and expect to get it out again the next day is the result of judges all over the country being faithful to the law, even if they would like to be sympathetic to somebody. The various systems and institutions that we have won't work if you can't rely on the law.
The profession of being an appellate judge carries anomalies and contradictions. A judge wants to issue a prompt decision, yet reflect before printing an opinion. A judge wishes to be brief, but yet be thorough. A judge wishes to exercise creativity, but also write with clarity. A judge might wish to ignore frivolous arguments from litigants, yet desires each litigant to receive a full hearing and know that he or she has been heard. A judge wishes to collaborate with his or her benchmates, but also wishes to project his or her voice. A judge wants to uphold convictions for crimes committed, but also desires to uphold the accused's constitutional rights, even if upholding those rights may lead to public criticism. A judge wishes to meet justice, but bestow mercy. A judge wishes to stand for principle, but not allow his or her personal bias to dictate his or her judgment. The staff and judges of the Court of Appeals look forward to another 50 years of diligence, integrity, and excellence as we continue to announce and apply the law, administer justice to litigants in the state of Washington, and serve our role as the intermediate appellate court and the workhorse of the Washington State appellate system.
Finally, I want to thank everyone who has worked in the Court of Appeals these last 50 years. The judges, their law clerks, their administrative assistants, the commissioner's office, the interns, the clerk's office. Every person in the Court of Appeals makes a difference every day. We're not able to do our jobs to deliver justice in Washington without the help of everyone. Too often I think people are not thanked for their service, and so I want to thank you very much for all of the service that you have provided to the people of the state of Washington. Happy anniversary.